How long will this take? Is probably the number one question I hear from executors when they come into my office. And the honest answer is, it depends. But I can show you exactly what the path looks like, step by step, so it depends stops being a frustrating answer and starts being a map you can actually follow. I'm Chad Graham, an estate lawyer in Edmonton, Alberta, and I'm going to give you some general information that does not constitute a solicitor-client relationship or specific advice to your situation. Here's what it looks like. Here's the pathway of getting to that grant and what happens when the grant is issued. Step one is the gathering phase, the original will if there is one, the death certificate, identification, your rough inventory of assets and debts. These are things I went over in the first video in this series. Check it out. You need these because they're the foundation of everything else. So that will take as long as it takes you to gather those things. Second, valuing the estate. This is a little bit bigger process. Once you've gathered that basic data, you're now going to investigate it. We're going to look for bank balances, property appraisals where needed, investment statements. And this isn't just bookkeeping, it's going to determine the cost of the court filing fee. Alberta uses a tiered fee schedule based on the estate's net value, although it's capped at a relatively modest amount. We're talking hundreds, not thousands of dollars. We're fortunate to have a very low probate cost here. Your lawyer will confirm the exact amount with you. Once you've done the gathering and then you've valued the estate, the next step is to do the preparation of the forms. This is something the lawyer will do for you if you hire one. This is the application package. Alberta's moved to a new set of forms as of about 2022 called GA forms. And there you'll have the application document itself, an inventory of the estate, notices that will go to every beneficiary, in certain cases to the public trustee. That last one, it's required anytime there's a minor beneficiary or a represented adult or someone whose location is not known. And there might be some specialized ones in your unique case, but this is the general idea. And getting these complete and consistent the first time is where delays are prevented the best. Once we've got the application prepared, then we have to serve notice and make sure every beneficiary and anyone with a potential interest in the estate actually receives formal notice of the application. All court applications are public. This becomes a public affair. Those who might have an interest in the estate need the opportunity to contest it if they want to. We can't skip or rush this step, or the court will simply send the file back. Then we have to file with the Court of King's Bench in surrogate matters at the judicial center closest to where the deceased lived. This can sometimes trip people up if they happen to pass away in a different place from where they lived, but that's something that we can help you determine. This is where, by the way, the lawyer-only digital filing system in an earlier video makes a huge practical difference. It's often the difference between a few weeks and a few months. Then the court's going to review it. The courts review at step 6. They're checking that the will is valid, that the right person is applying, that the paperwork is complete. If there's anything missing, a requisition is sent back, and this can happen for minor things. Or if you've done a DIY process and you missed a huge area, they may come back and say redo the whole thing. The clock is effectively paused at this point until you respond and get everything back to them. Then we have the grant finally issued. Step 7. A lawyer filed straightforward uncontested estate. This is probably a few weeks. A paper filed or a more complex estate, or when a lot more gathering is needed to be done and the court has to go through more documents, it can take longer. It can run several months. But either way, once the grant's in hand, interested parties are formally notified that the grant has been issued. Now, we need to reframe ourselves here because this is the part sometimes people miss. They think, yay, we've got the grant, we're at the finish line. No. This is actually the starting line. It gives you the legal authority to actually start administering the estate. That means collecting assets, dealing with creditors, and eventually distributing to beneficiaries. This whole next phase will be the topic of the 5th video. Now, if you want to work through this roadmap and maybe look at some specific side trails that will apply in your case, reach out for a free consultation. chadgrahamlaw.com, and you can book a consultation. And I look forward to talking to you or seeing you in the next video. Thank you.